We'll go ahead and get started now. Welcome everyone for our discussion of Justice Deferred, Race and the Supreme Court. My name is Tim Innes, and I'm a reference and academic outreach librarian at the MSU College of Law. This event is sponsored by the John F. Schaefer Law Library and the Michigan State University Inns of Court. A little background, this astonishing work of legal scholarship was brought to my attention by Patrick Rose, a local attorney and master of the MSU Inns of Court. He thought it might want to be a good idea to bring them to, I might want to interview them for my American Legal History podcast. So long story short, we decided to bring them here to MSU. Patrick has been the driving force in making this event possible, helping to raise the funds and write the interview questions. This event is made possible through the generous contributions of the following groups and individuals. First, Professor in Residence Nicholas Mercuro. Thank you very much. He's kind of got the ball rolling on this, so to speak. The MSU Office of Instructional Diversity and Inclusion. Thank you, Vice President Bennett. The Kelley Institute of Ethics in the Legal Profession. Thank you, Justin Samard, Professor. And Caitlin, the Institute's coordinator. And last but not least, the Michigan Political History Society, who gave a very generous contribution. I also would like to acknowledge the promotional efforts of the Black Law Students Association and their president, Lindsay Bonney, the Asian Pacific American Law Students Association, Caitlin again, and the Student Bar Association and their president, Caitlin Rajab. Bless some of the folks here at MSU Law that helped through the process. Ronald Blesser from our financial director, Amanda Spencer from the technology services, Catherine from communications, and Margie Amory, our director of events, who took me through a very complicated process, I found. So today we have two very special guests, Professor Orville Vernon Burton and Professor Armand Derfner. Their book, Justice Deferred, Race in the Supreme Court, is the first that comprehensively charts the court's race jurisprudence, addressing nearly 200 cases involving America's racial minorities. They explore the parties involved, the justices' reasoning, and the impact of individual rulings. Orville Vernon Burton is a prize-winning author of many books, including The Age of Lincoln. He is the Judge Matthew J. Perry Chair of History at Clemson University and Emeritus University Scholar at the University of Illinois. He was inducted into the Morehouse College Martin Luther King Colloquium of Scholars. He is also a recipient of the Southern Historical Association John Hope Franklin Lifetime Achievement Award. Armand Derfner is a graduate of Princeton University and the Yale Law School, and he's been a civil rights lawyer for more than a half a century, almost 60 years actually. As part of that work, he helped shape the Voting Rights Act in a series of major Supreme Court cases, and in work with Congress to help draft voting rights and other civil rights laws. He is currently the Distinguished Scholar in Constitutional Law at Charleston Law School. And these are woefully inadequate sketches. It's no exaggeration. I could take the entire time just talking about these two gentlemen's distinguished careers. So welcome, Professor Derfner and Professor Burton and Mr. Derfner. It's such an honor to have you with us today.
Thank you. It's an honor for us to be here. Thank
you. Well, I think they might be. Yeah, your microphones are on, so you're going to have to put they're attached to the wall, so I'm not quite sure.
Okay. Oh, they're tied down.
Okay. You want it to be a little closer to the people. Okay, so let's go ahead. So your book is arranged in a manner that's both chronological and topical, and I will structure my questions in the same manner. In your introduction, you state, and this is paraphrasing, Americans typically think of the Supreme Court as the guardians of both law and liberty that ended segregation, guaranteed free trials, and protects free speech and the right to vote. But the reality is more complicated, especially in the area of civil rights. In this area, those accomplishments date from a relatively short period in history, from the early 1930s to the early 1970s. Before that time, the Supreme Court spent much of its history ignoring or suppressing those rights. And in the half century since the early 1970s, the court's record on civil rights has retreated far more than it has advanced. Oh, here it is. So I want to start with two cases which were major catalysts in igniting the Civil War. One most people will be familiar with, and the other probably not. And they're Prigg versus Pennsylvania in 1842, and of course Dred Scott versus Sanford in 1857. So the first questions I have for you, in Prigg, did the U.S. Supreme Court effectively find fugitive slaves to be mere property and not human beings subject to federal rights protecting their liberties? And did Prigg effectively nationalize slavery laws under the Fugitive Slave Clause in 1842, insofar as recapture of persons alleged to be fugitive slaves were concerned?
Prigg is a case that deals with the Fugitive Slave Clause, and it's important not just for what it does, but you're all law students. We would encourage you to go back and read some of these cases, which I guess is pretty easy now. You can get them on Westlaw or Lexis.
They're also on our website.
And
We put them there, so.
So if you look at Prigg, Prigg is a perfect example of how the Supreme Court majority twisted the law and logic. The basic holding of the case is that the federal government, not individual states, gets to enforce the Fugitive Slave Clause. But what's most interesting and what we point out is that the court took the Fugitive Slave Clause and expanded it so that rights that should have been recognized were not. So that the court really went further and turned the Fugitive Slave Clause into a paradise for slave owners by making it irrelevant whether the person who the so-called fugitive slave really was a fugitive slave or not. The court says that all that has to happen is that a white person comes in and says, this is a fugitive slave, and I can take him back, and it doesn't matter. The federal statute had said that he had to prove to a commissioner or a magistrate that this was the person who was a slave, and the Supreme Court said he doesn't have to do that. So that was one of the early instances of not only how the Constitution favored or protected slavery, but how the Supreme Court went overboard, ignoring law and logic, and just invented new doctrines that made slavery even worse than it would have been by itself.
It involved a certificate which was required. And to start with this, it's one of the first cases where, as a historian, and this really is a book by a historian and a law professor, a civil rights lawyer, and I've often said I don't think any historian could have written this book, and Armand sort of agrees, I don't think a law professor could have. It really is the two of us trying to put this together. And I learned, particularly from this case and then the rest of the case, how important it is to read the dissent. You know, most of us historians would explain things well, like at this time, people didn't know better. They felt that they were doing this. But you look at the dissent, Judge Story, who had been very good in the Amistad case, you know, does this turnaround, which is sort of disappointing for those of us. But Justice McLean, I believe it is, isn't it? Justice McLean writes very clearly that African Americans are human beings with the rights of human beings, and so it's there, and they still go against. And you really see that in Dred Scott, which will come next, I think.
Yeah.
But the idea that they, over and over again, you'll see they make it the federal law to enforce when it benefits those people who are enslavers, and it goes toward the state, particularly in race relations later, when it is against minorities, particularly African Americans. So that you'll see a pattern as we go through these cases that I think begins right here.
Yeah, and we would encourage you as law students, take a look at our description of the case and then read the case itself, which, as I say, you obviously all have access to. And I think you will see one of the things that is most distressing throughout most of the Supreme Court's history, especially the early period and the current period, is the way the judges manipulate the cases. And it's that's why we try to put a combination of history in with enough analysis of the cases so that if you take a look at it, you can make up for your own minds about whether you think the justices have really been faithful to law and logic or whether they're just doing a number.
And we welcome criticism. We both do. I mean, feel free to disagree. When I lectured at University of Illinois, I made students show that I was wrong on their exam or one of my lectures. Particularly, Armand is thick-skinned, but I had 5 daughters, and little girls think that their daddies can walk on water till they become about 12, 13, depends on the child, and suddenly you can't swim, though you're doing the same things. You can't hurt my feelings after 5 teenage girls.
Or mine.
Who had to deal with my daughters, too.
Let's move on to Dred Scott. Did the U.S. Supreme Court in Dred Scott stop Congress from banning slavery in the territories? And did it effectively nationalize slavery in terms of property rights? And what was the reaction in the North when the Taney Court ruled that African Americans, whether free or slaves, were not citizens of the United States?
Yeah. First of all, we like to remind people that Harriet Scott is part of this, and this is one of the fascinating cases. I think you folks are the attorneys, but certainly historians sort of think this is probably the most notorious or infamous case, although Armand and I sort of think that a 2013 voting rights case comes pretty close to being as bad, and we will see. But one of the lines that we have in here is from the lower court on this, where the justice says things are not as they were. Of course, he's talking about the Civil War. But literally, Dred and Harriet Scott, if they had lived in Mississippi or South Carolina, there were cases where under those, they would have been free. So once again, you're going against precedents, which we can see in current things that go on. And I'm going to jump ahead because this is something Armand wouldn't let me put in the book because he said we'd beat up on Justice Roberts so much. But what does Judge Roberts say in Shelby County, and actually Mudd as well? It's basically things are not as they were, just like the Missouri judge had said. And then what does Judge Alito say in Bronovich, in 2021, which we should not do, at least as a historian. We predicted that case, unfortunately, successfully, of what would happen. He says, today is not like 1982. You see the pattern that goes forward with that. But your answer to your questions is basically yes. And you didn't ask about the North, but the idea of, none of this was necessary. The decision was just, could Dred Scott take this case forward? It could have been the end, but Tony used it to move forward an agenda. And it's tied up, we talk about the sort of presidential conspiracy of Buchanan, that this is going to be the solving of the nation's problems. It's going to keep us from having a civil war. Just the opposite effect, because it brings someone like Lincoln saying that, particularly after popular sovereignty, 5 years or so later with 1854, but even then that now you can't take a neutral stand, really, because slavery is a national problem. You can't keep it out of Illinois. He says that if you go by this court decision. And of course, this court decision is why you have the 14th Amendment, the very amendment that's going to be argued Thursday at the Supreme Court. That amazing amendment that has so much in it is to undo the Dred Scott case. We can go into more details. I can't remember exactly what your question was.
Well, the question was what was the reaction in the North?
Oh, yeah.
And that was...
I thought it was the South, actually, and I did the North.
The reaction in the North.
Well, actually, both. It aroused terrific reactions. In the South, they said, basically it put all the moderates and unionists behind the eight ball, and it really energized all the fire eaters, the ones who said, we want slavery everywhere. So it got them to be more extremist. And in the North, the reaction was, I think Horace Greeley, who was a newspaper publisher, said, this decision doesn't have any more weight than something uttered by a bunch of guys down in the corner bar when they got drunk. It's totally useless. So it really, for a decision that the court hoped would, quote, end the question of slavery, disputes about slavery, it did just the opposite thing. But what we did was we tried to put both the historical context in, but take a look at the decision. And people think of Dred Scott as the decision that said, which it did, that a Negro has no rights that a white man is bound to respect. And that is what catches everybody's eye today. But at the time, it was the other half, the part that said the Missouri Compromise, you all remember that from your high school days, the Missouri Compromise is unconstitutional. Missouri Compromise had been adopted in 1820 to try to referee between the North and the South by saying in the territories west of the Mississippi, which were not states yet, you can have slavery in the ones in the South, but not in the North. And what the Dred Scott case did was to say, oh no, the Congress has no power to ban slavery anywhere. So the part of the Missouri Compromise that said no slavery in the territories in the North, like Michigan would have been part of the Northwest Ordinance, I guess, that was just thrown out. And it's what we tried to do I keep coming back to the technical side of the case. If you take a look at how we described the Dred Scott case, we talk in detail about the court's reasoning in saying that the Missouri Compromise was unconstitutional. And so I would invite you to look at that, take a look at the case, and take a look at what we said, and make up your own mind about whether you think the Supreme Court was doing honest work or just twisting the law to meet their own desires.
And when we think about the partisanship and the criticisms of the courts that Judge Roberts is trying to tread now about the partisanships in the courts, this is exactly what happened there with the president, who lobbied, in fact, northern justices, so it wouldn't just be southern justice versus northern justices, to support the Dred Scott decision. He knew what the decision was when he said, of course, he would follow whatever the decision would be. So it's a long line of partisanship and court decisions that you can see reflected early on in Dred Scott. That's another, I think, important of reading the dissents. When he says there were no rights that black people had. Black people voted at the time of the Constitution in the United States, even in the slave state of North Carolina, until after Nat Turner, free African Americans voted on the same basis as whites did in the slave state. So they knew that because the dissent lays it out. So you get the sort of flavor of what goes on in terms of the decision and the politics involved.
There you go. Okay. I want to take a few minutes to discuss the Civil War amendments, in particular the 13th, and quoting from your book, the 13th Amendment continues its promise to end the badges and incidents of slavery, root and branch, to guarantee equality, and ultimately to end discrimination and eliminate racial prejudice. The spirit of the 13th Amendment is at the heart of the Constitution. That spirit animates this book, close quote. One more thing, you offer a very simple definition of badges of slavery, which will help clarify the rest of the questions. And here's your definition. The badges of slavery meant the practices or concepts that were associated with slavery that remained even after the institution was formally abolished. So this is a big ask. So in an effort to kind of lay out the foundations of all the cases we're going to discuss today, can you explain sort of the meaning and the purpose of the 13th and 14th and 15th Amendment.
I'll start, then you pick it up. I love to say that what Abraham Lincoln did with the 13th, 14th, 15th Amendment, and knowing, of course, that he's dead by the time the 14th, 15th, even the 13th is finally ratified, but even after that, they were doing it in Lincoln's legacy. He took what was our mission statement, the Declaration of Independence, and put it in our rule book, the Constitution. Literally, it is taking positive liberty, the negative positive liberty debate that Isaiah Berlin was famous for in his 1957 book. Lincoln understood exactly what that meant even earlier, because the Constitution, of course, with the first 10 amendments, literally laid everything to the states, so instead of the federal government to enforce it. So everything was by states' rights. And Lincoln, after the Emancipation Proclamation, received a Bible from an African-American church, and he wrote a letter and spoke to this exactly. And typical Lincoln in this great story where he says the United States has not ever had a good definition of liberty. And then he says that we do now, thank heaven, but he says, you know, the sheep thanks the shepherd for protecting him from the wolf. But the wolf complains that he has been denied his liberty by the shepherd stopping him from eating the sheep. And he made it very clear when he was talking about this, that's especially true if the sheep is a black one. So that's what we do with the 1340. It's been called the second founding. It changes the Constitution. And one of the things I think will come out, and Armand can talk more about it, is some justices could not accept that. They still, in the old definition of federalism, were so hung up with the states' rights that they didn't. But that is the new Constitution. That's the Constitution today. So we both argue that if you're an originalist or you're a textualist and you argue that the First and Second Amendments should be interpreted as broadly as they can, as some justices do, but then you look at the 13th, 14th, and 15th Amendment, and you read them as narrowly as they can be. There's an inconsistency there, because the 13th and 14th and 15th Amendment are, in fact, just as important as the First and Second, and certainly for modern America, they have to be understood that way. And as we get to later in Armand, we have really worked to dismantle what was an incredible idealistic change in our Constitution to try to live to make the United States the last best hope and continue to be with this idealism. There's a lot of antagonism and hatred came out of it, but there was a lot of idealism, and those are expressed in that 13th and 14th and 15th Amendment. And you talked about the 13th Amendment. You only need the 14th because the 13th was not done as and respected as it should have been. And there's a lot of stories all explained in the book. I've talked too much. Armand, go ahead.
I think that was a good answer.
Yeah, yeah.
By the way, let me ask this. Anybody here see the movie Lincoln? A handful of people. Well, that movie got across how much controversy there was. We think that 13th Amendment is an automatic thing that everybody ought to be in favor of, and yet it took a lot of political log rolling and deal making to get it through. Because in those days, it's sort of hard to imagine now when we see what the Democratic Party is today and the Republican Party is today. But in those days, the Republican Party was a new group that had arisen sort of inspired very much by abolitionism, or even if not abolition, at least a sense of free soil and an opposition to slavery. The Democratic Party was lock, stock, and barrel for slavery. It was a criminal conspiracy for slavery and for racism. What were some of the Democratic Party had in their platform? All kinds of what was it? Some of the stuff they had, Vernon?
Yeah, well, I have in the Age of Lincoln where I put their platform and things. But what is really amazing is, of course, the Republican platform answered that. They took their they took their accusations of racism and took them head on as an anti-racism, which is one of the few times I've ever seen that in American history, where you actually, a party is taking the kind of things like miscegnation and taking it head on and saying that we're not going to be racist. It was both 64 and the 68 elections that way.
There you go. Okay, so one of the interesting facts about the Civil War amendments, it was the first time that Congress was afforded new powers under the Constitution since its original ratification. And the last section of each says, Congress shall have power to enforce this article by appropriate legislation. So the amendments were given teeth through the passage of 30 federal statutes, but 4 were really the foundation stones for Reconstruction, and they are, of course, the Civil Rights Act of 1866, the Enforcement Act of 1870, the Ku Klux Klan Act of 1871, and the Civil Rights Act of 1875. So here's your question, and then we'll get into these cases that deconstruct Reconstruction, so to speak. So at first blush, so to speak, with the amendments ratified and the laws in place, or in the case of the Enforcement Act of 1870, the law in place and the amendment ratified, and especially after the radical Republicans had taken over the Reconstruction process, initially, how successful was this great experiment in social engineering, and what was the reaction to these radical changes in the social order in the South?
Well, I'll just quickly say that I think Reconstruction is the most important period in American history and the most misunderstood and misinterpreted. People are always fascinated by the Civil War. If you want to write a book that's successful, write about the Civil War. They don't that much about Reconstruction. You can understand that to a certain extent because people argue the identity of America is there. The more people killed, the issues are issues we still argue over today. What is the place of people who are perceived as different in the society as a war develops, a war about union, what is you? But I would argue that what we become is actually hammered out in Reconstruction. And we hint at it here, but I really argue it in the age of Lincoln. You cannot separate, as far as I can tell, the Civil War and Reconstruction. In terms of what happened, people think of the South as white, but in fact, as I argue, certainly South Carolina did not lose the Civil War. A majority of the people in South Carolina were African American, and they wanted the Confederacy to lose. And if you look very carefully, you'll see how many old white Unionists there were, old Andrew Jackson Unionists. Every single state except for South Carolina had a regiment of whites fighting for the Union. You add that with a number of black soldiers, and you really are getting into a pretty equal number divided who are actually fighting for the Union, and that comes over. So for black people, it was an exciting time. They knew what they wanted, they knew who they wanted to vote for, and through legislation, as long as they had the vote, they made a difference in changing that society. The most progressive constitutions come out of that period, and not just in the South. It becomes to be reflected. Look at the constitutions written in Illinois and Michigan during Reconstruction, reflecting some of that idealism. One of the problems, of course, is with Reconstruction when Lincoln is dead, and I don't want to put too much on Lincoln, but Andrew Johnson really shifted, and we try to show that through appointments and specific cases, how it affected things. The first state after Lincoln was gone to be admitted is Andrew Johnson's birth state, North Carolina. Lincoln's cabinet was divided equally on whether to readmit states with the 13th Amendment. Did they have to accept black male suffrage? Evenly divided. Johnson didn't consult. He just put in a grandfather clause that said, with the North Carolina that becomes a pattern for the former Confederate states that are admitted in, that only if your grandfather voted 1860 or whatever year he said, could you vote, which basically disfranchised, and that becomes the pattern. So I think we have to understand, to give you an example, public education as a state was first introduced by Robert Smalls, the great Civil War hero, in South Carolina. And it's South Carolina, I think about the pathetic school system I came through in rural South Carolina, was the first state to insist. Well, they need to teach me to do a lot of things, but thinking's more important than talking, Armand. I'll do the thinking, you do the talking. How about that? So literally, you have this very progressive thing for both black and white. But that's not the way history was written. We actually talk about that in the book, too, how usually they say, you know, the winners write the history. That's not what happened, particularly with Reconstruction. Let alone the Civil War. I should let you pick this up where I'm going with it. I can go on and lecture forever, as you know, my favorite topic.
Yeah. Well, I was going to refer to one of the interesting aspects of what Professor Innes is talking about the legislation. We just talked about the Democrats and the Republicans. The Democrats would never agree to any of this, but in an event that sort of is like what we're going to hear about from the Supreme Court this Thursday, I guess day after tomorrow, the Democrats had all left Congress during the Civil War, or even before the war started. They left as soon as South Carolina seceded in late 18...
Democrats.
What? The Southern Democrats. The Northern Democrats stayed, but they were a smaller number. But the Southern Democrats left. After the war, Congress had been out of session in 1865, starting in, I guess, March. In the old days, Congress didn't convene every year till December. So they were out of session. Lincoln was murdered, and then Andrew Johnson becomes the president. The 13th Amendment is ratified in late 1865, and at that point, the Southern Democrats started to try to come back to Congress, and they had not been given amnesty. What the people in charge, which were still the people who'd been in charge before, sent back to Congress basically the same people who had led the Confederacy and led the secession, and they all got thrown out. Congress, which was mostly Republican with some Northern Democrats, in 1865 rejected all the senators and representatives from the southern states who had sent back all these Democrats, mostly wartime governors, et cetera. And so at that point, Congress was in the hands of the Republicans, many, but not all of whom believed in a real Reconstruction. They passed the first civil rights law. Andrew Johnson vetoed it. His veto was upheld by the narrowest of margin. A few of the Republicans, instead of voting to override it, said, well, let's give him a chance. After that, he vetoed, I think his vetoes were overridden 14 straight times because the Republicans who were in charge, even the more moderate ones who were not so much for Reconstruction, saw that if they let Andrew Johnson and the southern states at that time have their way, there wouldn't be anything to gain from the Civil War. Things would have gone back the same as they were. So there was a lot of politics that took place that led to the 14th Amendment and the 15th Amendment, and led to a lot of the laws that Professor Innes has referred to. So you got to combine the legal history and the political history, which is, I guess, what we tried to do in the book.
And just to mention the 14th Amendment, which is going to be Thursday, so central to the Supreme Court. I just did a legal brief, myself and another person. We had 25 historians, including Alan Lichtman and I, who wrote it, to sign.
You can get it on the Supreme Court's website. It's a great brief.
Well,
Actually, we're going to talk about it at the very end. I have a slide about that.
Well, maybe I can wait, but I just thought one of the most interesting things is to jump ahead. When amnesty is given, I mean, that's the way you handle it, with amnesty given, then what happens is, who do they elect after Reconstruction? It's the people during when Democrats get back power. It is those former Confederates, and they lead a counter-revolution that overthrows a legitimately elected interracial government, the Republican government, a biracial government. You have a coup d'etat in America. It is not just economic threats. That you have terrorism. You know, terrorism we think starts in 9/11 in America, but the United States for African Americans lived in a terroristic society at least until 1965.
And any white people who might want to cooperate are also terrorized.
They were
murdered,
killed.
driven away.
They were killed,
Yeah.
literally, many of them who were targeted. And that was deliberate campaigns. It's the kind of part of Reconstruction and the overthrow of what was an idealistic period that's not in those textbooks that needs to be.
Okay. So kind of the high watermark of enforcement of these laws came in 1873. There were more than 1,200 civil rights prosecutions under the Enforcement Act of 1870 and the Ku Klux Klan Act of 1871. Now, as you point out in your book, by the mid-1870s, the political will to maintain Reconstruction was in decline for a number of reasons. The political ramifications of the financial panic of 1873 fell hardest on the Republican Party. Growing labor unrest, administrative costs, the passage of the Civil Rights Act of 1875, which a lot of Northerners did not like, fierce Southern resistance. There was even, most people don't know this, there was even an enormous plague of locusts out on the Western Plains in 1874. And in our discussions yesterday, Professor Burton made an interesting analogy to our current support for Ukraine waning. And then, of course, there's the election of 1876, which we don't have time to get into. So let's get into these cases. Now, Chapter 3 of your book is entitled The Supreme Court in Reconstruction, and in it, you analogize the Civil War amendments, and more importantly, the enforcement statutes designed to accomplish the goals of Reconstruction as being like bricks in a large wall designed to keep at bay the forces of oppression and injustice. So in the decade from 1873 to 1883, the Supreme Court decided 6 major cases that removed the essential building blocks from the wall of protection that the Reconstruction amendments and statutes had erected. So in 1873, 1876 twice, 1880 and 1883 twice. And as you stated in your book, when the cases were finished, the wall was all but gone. So what we're going to do now is run through these essential cases that destroyed Reconstruction. And the first 2, we'll take them 2 at a time. The first 2, and one I'm sure most law students are familiar with, is the slaughterhouse cases in 1873. And the second, which they probably aren't, but should be, is, of course, the Cruikshank case in 1876. So slaughterhouse, which removed the first block, concerned the butchers of New Orleans. And Cruikshank was the result of a horrific Colfax massacre in the small hamlet of Colfax, Louisiana on Easter Sunday, April 13th, 1873. So here's the questions regarding both. How did the federal courts in the slaughterhouse cases give a narrowing jurisdictional interpretation of the scope of federal powers to enforce the 14th Amendment, inconsistent with the intent of the framers? And more specifically in Cruikshank, which you devote 6 full pages to in your book, and in the end, which you say the Cruikshank case removed the second building block of Reconstruction's wall of protection, the enforcement clause in Section 5 of the 14th Amendment. So how did this case facilitate that removal? So slaughterhouse and then Cruikshank.
Well, slaughterhouse, when I've taught con law, I ask students at the end of the semester, what's the worst case you've read, the stupidest case you've read? And slaughterhouse cases always winds up in one of the top 2 or 3. I don't know if you've ever been asked that question, or you've had a reaction, but you've all read, if you take con law, you've read slaughterhouse. And in that case, the Supreme Court came up with the idea that when the 14th Amendment says no state shall enact or administer a law that denies the privileges and immunities of U.S. citizens, the Supreme Court decided that that meant not the privileges and immunities like speech or other things in the Bill of Rights or the right to earn a living, but meant everything besides those. They said all those things are privileges of the states and not U.S. citizens. So the U.S. privileges are so narrow, like the right to protection on the high seas, the right to go to Washington, D.C. So in that way, the basic rights that we think of in the Bill of Rights were all kept out of the 14th Amendment. And what's interesting about that, and Vernon, you can talk about this, is why that happened. Was the Supreme Court motivated to do that?
Well, I don't want to spend a lot of time on this, but of course the butchers, most of them had fought in the Confederacy. They were Confederates, and their lawyer had been on the Supreme Court and left to become a high-ranking officer in the Confederacy. I've forgotten exactly which title he had, but it was very, so there was a lot of animosity toward him as well. In fact, one of the most interesting things that I mentioned in the debate with the Federalist Society is, of course, Slaughterhouse says very clearly that the 13th and 14th and 15th Amendment, and it listed out, were there to get rid of those badges of slavery that is for black people.
And the problem was that the plaintiffs in the Slaughterhouse case were white butchers trying to challenge the laws of Louisiana passed by the biracial state legislature.
And also because they were throwing all these carcasses and, polluting the Mississippi River in the area, and people were dying. So it gets complicated. You have people who were caring about the environment. Sounds like today, but very much so. But what I think people have ignored is how, if you're an originalist and a textualist, Slaughterhouse case, as bad as it is for what it does in the future, also says 13th and 14th and 15th Amendment are there to get rid of those badges of slavery, just explicitly for African Americans.
Basically, they said this is the 13th and 14th, 15th Amendment were for African Americans, not for white people, and we're not going to give these white people anything in this case.
It's just the opposite of what they say later about undoing affirmative action of the 14th Amendment and everything else. And it doesn't say anything about it's for corporations either. So,
but what it does is it effectively removes the privileges and immunity from the 14th Amendment as ineffective. And since then, it's
and it limits, as Armand says, just everything except.
Now, the one justices, as you know, over a period of years, a lot of the provisions of the Bill of Rights have been incorporated in the 14th Amendment through the Due Process Clause and thus applied to the states. The court has never gone back on the Slaughterhouse case interpretation that privileges and immunities does cover a lot of the Bill of Rights. Only one justice has written that explicitly, I think, and that's Justice Clarence Thomas, who has said specifically that Slaughterhouse ought to be overruled. Everybody else just sort of tiptoes around it.
Okay, let's move on. So on the very same day that Cruikshank was decided, March 27th, 1876, limiting the 13th and 14th Amendments, the Supreme Court struck at the 15th in the case of United States versus Reese. So while Cruikshank weakened one section of the Enforcement Act of 1870, Reese took aim at two other sections and held them unconstitutional. Can you tell us about that case?
You like that one?
Well, I like the word aforesaid. One word on the 15th Amendment, and Cruikshank too, we spend a lot of time on because it's so important. Let me just quickly mention that we think of 1876 as sort of long ago back time, but all these former Confederate leaders, so many of them were attorneys. They were tied in Mississippi. They corresponded about how they did Mississippi in South Carolina and modeled it once it was. When Cruikshank came down, and it says that unless it's state involved, state action, that you literally cannot convict white people of murder if they're not part of the state, and you only have white juries, of course, so it's not going to happen. Immediately, in 1870, there was the infamous Hamburg Massacre in South Carolina. It was like opening up the door. And then you had, it just was massacres, and people could get away with it. But the aforesaid, and Armand and I went through it very carefully, and it even has a repeated clause. It wasn't very even cleaned up as a case. there. But the aforesaid, the judge literally said, having used aforesaid himself, says it doesn't mean black people or race beforehand, and it just nullifies what is the 15th Amendment. It just took the tooth out of it. You want to explain the legal part of that? I mean, that's basically it. But one word, one word, aforesaid, which this very judge we showed had used in another case himself. It shows just how bad it could be.
Yeah, you might want to actually read the Reese case, which is discussed
And
around
the Cruciate.
68 or 69, page 68 or 69. But Reese was a case in which sections, I think, 2 and 3 made something a crime if it was done, made rejecting a person's ballot a crime if it was done on account of race. Section 4 said if you reject a crime, if you reject a ballot on the grounds as aforesaid, obviously referring back to Section 2 and 3, then that's a crime. Well, the Supreme Court says, well, Section 4 is unconstitutional because it doesn't refer at all to race. And yet the word aforesaid obviously referred to the previous sections, which did refer to race. And as one of the dissenting judge said, well, what does aforesaid mean if it doesn't mean the sections that just came before? And as Vernon says, the justice who wrote the opinion, Justice Waite, who was President U.S. Grant's 5th choice to be Chief Justice, and this case shows you why he was the 5th choice. He didn't have any answer, and he, as Vernon said, had written a case not long before in which the word aforesaid, he said, well, it just means what they said in the previous section. So this is an example of why we would invite you to sort of pick up any case discussed here, and if you go through those cases year after year, you won't find any honest cases. You won't find any cases that you would be willing to stand behind.
Okay.
We hope you do it.
Right,
Professor, are there any reactions from the students so far?
You want to wake a few people up?
Yeah.
We'll see. Okay. Anybody want to ask a question at this point?
Or comment?
Okay, go ahead.
I do.
Okay,
I'm
Brad.
not a student though, so I defer to the student if anybody has them. You have mentioned the sort of twisting of language in the law prior to the Civil War. We know what happened after that. Then you say that alarmingly it's coming up again. I wouldn't go so far as to say history repeats itself, but lyrics rhyme, I suppose, sometimes. I guess this is, given the reappearance of this language and the current trying times, how as advocates, particularly as aspiring attorneys, how does one maintain faith in the system as a whole? How are we going to be able to fix this?
It's a very good question.
We struggled at night over and over again how to end the book because we were, as we wrote into the 70s, it was pretty exciting. And then we begin to see the dismantling. But it's a great question. I have an answer, but Armand.
Go ahead. You go ahead.
You sure? Okay. I wanted to get to, I asked, because it's not Justice Hughes. Armand's a Princeton undergraduate. I did my PhD at Princeton. In those days, we hadn't quite got to understanding about Woodrow Wilson's leading segregation and segregating the federal government. And so if we look at Charles Evan Hughes, he was the corporate lawyer, sort of like Lincoln was the railroad lawyer that ran against this progressive. And I want people to remember that despite the segregating of the federal government, Wilson was considered one of the most progressive presidents and good for labor and other things. But then we looked at Charles Evan Hughes, and this is sort of when he comes on the court, he's on twice. But Charles Evan Hughes was an devout American Baptist. His father was an American Baptist missionary who had immigrated into New York, and he literally lived his faith. And this was interesting. The first case, I believe, and Armand can correct me, is Scotch, but he did so many. And we have a picture and illustrations in our book of some of the cases he did. Until that time, when these cases came forward, the Supreme Court had always said, well, you know, the Supreme Court of South Carolina, Alabama, Oklahoma had said that it wasn't about race, you know, and so the decision stood, these horrible cases. Charles Evan Hughes said, I'd like to see the evidence. And the evidence was there. It was there in the jury list. It was there in everything. That back then, people weren't as careful about hiding that they had noted that people were black or whatever on the list so they wouldn't be called to the juries and things. And that begins a turnaround that we think of the Warren Court. And I think that's one of the ways to be hopeful. Evidence matters. Despite historians beginning to follow English departments and talk about the construction of history and postmodern history, evidence matters. Alternative facts are alternative facts. They're not the history. And if we can present the evidence, I've, as expert witness, seen several judges who ruled by the law and with the evidence even when they didn't want to. The second thing, now I have it on completely, both of these on airplane mode. I don't know how this is happening. I swear I do, because I've got it doing it. I don't even understand. Okay. And it's spam anyway. The other thing is where Armand and I ended this book. I really do believe that we have made a huge difference, particularly public school teachers, doing God's work and literally teaching what I knew when I went to Princeton and graduate school and right after the Army in '69, that Reconstruction and the Civil War is about slavery, but it takes a long time for that work down in education, schools. Young people have been taught that now. They do not want to discriminate. They want to be open. Look how quickly people accepted gay marriage. I never thought it would happen, and things like that. Young people really don't like to see people disadvantaged. So I think with evidence in that, and for the first time, I think in our history, and Armand probably knows better than I do, the court is out of step with the American people. You saw it in the overturning of Roe. You see it in a lot of things, I think. Back when they were doing these horrible slaughterhouse cases and everything, I'm sorry to say, I think that probably most of Americans agreed with them. Not all, but most did. I think those two things give me hope. How long can it stay out of that? And I don't think young people are going to put up with it. What we need to get people to understand is a winner-take-all election for the presidency in the United States. We're not a parliamentarian form of government, and the president gets to nominate Supreme Court justice for life and all the federal justices who make a difference. But I get my hope from young people. I'm just amazed at how they want to do what's right and that evidence matters. And if we don't have a rule of law, which is what Lincoln struggled with his whole life, how can you have, except on one side, anarchy and the other authoritarianism? And I hope people can understand that. And that's where I have some faith that, or I'm not sure Armand agrees with me on this.
Well, I would, like Vernon, put some emphasis on the fact that, at least in my view, today's court is out of step on many, many issues with the general public. And the justices are independent, and they can write whatever they want to. At the same time, they can't keep it up forever. And when the court in the 1930s was really out of step with the public, that changed. And part of why it changed was that one of the justices came to see his role as a justice in a very different way. And other justices retired. the court could not prevail standing against the people. It may take a while, and we may find lots of decisions we disagree with, but advocates have to keep advocating. People have to keep writing. If you write law review articles, or if you write newspaper columns or letters to the editor, the weight of the people, I think, will prevail. It may take a long time. By the time the 30s court came along, the court had been doing terrible things for many years. But we can't give up. And if you think the court is out of step with your views, then you need to do something about it, whatever your role is.
And everybody needs to vote. And I'm not trying to tell people how to vote. But then secondly, of course, organization. That's always been the way in the United States. Small groups from the abolitionists forward have organized and lobbied and worked. And
there are dissenting opinions, and Justice Brandeis said a dissenting opinion is an appeal to history. So even if some things, some things that I may not like today may not change while I'm on this earth, but they will change. One of the things that people accuse us of, both of us, is wearing rose-colored glasses, because we somehow have a faith that we will come through. The country has been threatened before. It is threatened right now. Whoever is against the threats, we need to do what we can to make sure those threats don't come to pass. If you're in favor of the threats, that's a different story.
I found it very ironic. When I wrote The Age of Lincoln, I argued about this terrorist overthrow of Reconstruction, that it wasn't most white Southerners. The great majority were not riding with these terrorist paramilitary groups. It was a small group. The tragedy was good people did nothing. People who believed it did nothing. And then you had the coup d'etat. And yet I find myself today, and sort of the question you're asking, what can I do when I see the echoes, not history, but the echoes of a threat to democracy, the rise of authoritarianism in the world, just as it was at the time of the Civil War, where the Confederacy was much more in line with the rest of the world moving toward authoritarianism than the United States was, the Union. So I think I found myself struggling the same way, having sort of accused people of a different period of not doing something. So you do what you can, I think, like write a brief to the Supreme Court.
All right. Well, time is starting to be an issue for sure. So
Sorry,
we're going to
Tim.
have to move on.
Shouldn't ask lecture. Yeah, his story knows a 50-minute answer or lecture period.
That's true. Let's talk about one more case from this period, and that is this one. So by the 1880s, these before-mentioned cases greatly weakened the Civil War amendments and the Reconstruction statutes. But one question remained, whether Congress could enforce the rights contained in the 13th and 14th Amendments against private persons. And that question was answered definitively in the civil rights cases of 1883. Before we get into that, one thing I learned from your book, and I did not know this, is that for centuries in England and the early United States, operators of public accommodations had been required to accept all orderly travelers and customers. So what was the essential holding in the civil rights cases?
Take that, Armand. I've talked too much.
The Civil Rights Act was passed in 1875. It was actually passed by a lame duck Congress. The Republicans had lost control of the House to the Democrats in the 1874 elections, but in those days, there was a whole lame duck session of Congress that came after that election, and on the last day of it, Congress passed the Civil Rights Act, which said it said you couldn't discriminate on account of race in selecting juries, and that was upheld, although applied in a strange way. But it also said you could not, that people who operated common carriers or places of public amusement, basically restaurants, taverns, hotels, etc., could not discriminate on account of race. The Supreme Court said Well, the 14th Amendment doesn't authorize that because the 14th Amendment just deals with state action. And this law says that private citizens can't discriminate, not move, opera houses and the like. And that they were probably correct in that. But they also held the 13th Amendment does not authorize it. And I think that's a much more interesting part of the opinion because to my mind, the right to be treated as a customer in places that accepted everybody else. You went to a restaurant, the restaurant accepted everybody, and as Professor Innocent pointed out, had to accept everybody, yet they were saying, we're not taking African Americans. And the 13th Amendment, I believe that was a badge of slavery, and the Civil Rights Act should have been upheld under the 13th Amendment. So if you read Justice Harlan's famous dissent, I think you will take a good look at the 13th Amendment part of it. That's also the case in which Justice Bradley, who wrote for the majority, had the famous little throwaway line at the end saying, it's been 20 years, it's time for these ex-slaves to stand on their own 2 feet and not be the special favorite of the law. The same justice who had written opinion after opinion, striking down attempts to protect the newly freed slaves.
All right. So what I think I'm going to do is I'm going to, yeah.
I wanted to ask a question real quick.
Okay, go ahead.
I listened to Tim's podcast with the authors, and I want everyone to know about that and to have a chance to listen to their answers on the second half of the book.
Yeah.
And I know we don't have a lot of time. There were 2 things in your book that just really impressed me in understanding the world we live in. And I wondered if you could, in the last, 10 minutes or so, just tell us these 2 stories. One, you start in the introduction and you say that the suburbs didn't segregate themselves.
Yeah.
And in the middle of the book, you tell a story about housing development in New York City where MetLife cleared 18 blocks and $90 million and only whites were allowed to live in that development. And somehow the US Supreme Court upheld that and didn't follow its equal protection law decision from the Wickrow case with the laundries where it said you can't apply the law unequally based on race. And you tell the story about how this Dorsey case from 1950 allowed an entire building of the suburbs that was largely built on racially exclusionary zoning and all kinds of other factors that the Dorsey case could have resolved. You tell that story, and I wondered if you could talk about housing segregation. And you also tell about Brown versus Board and the notion that it wasn't implemented immediately and it led to massive resistance and closing of schools in the South, and there weren't desegregation remedies, and it was extremely slow and took all the way until 1968 for the Supreme Court to make desegregation remedies have real teeth. And that's the point when Nixon got 4 justices and they began to take away the federal court's power, and now our schools are more segregated today than they were in 1954 when Brown was decided. And those 2 stories about the housing segregation we live amidst in this country and the education segregation come from these cases, and you just really tell that story, and I wondered if you could talk about that.
I'll let Armand do it, but I think the point we tried to make was these were state interventions that the continuing, as we argue, 12 generations since these first discriminatory laws. There's no such thing as race. I mean, that's something we all have to understand, whether you just say genetically, there's no difference between a Lutheran Presbyterian, an African American, or Ukrainian, or as my mother says, or taught me that all are created in the image of God. And yet these laws created distinctions which produce racism. And I think that that's important. Going back, I see that Tim has the one of the covenants that are there and things. But Armand, tackle that, and then I've talked too much on this. But both of these things I think are important.
Yeah. Patrick mentioned the Stuyvesant Town case. This was an early example of what we would today think of as state action. But in those days, the state action doctrine was really not well developed. They were still sort of enthralled to the civil rights cases where they said, well, if it's private, and it's not state. So here comes Stuyvesant Town, the first gigantic housing project, a middle-class housing project that covers many blocks in New York City still to this day. And Metropolitan Life Insurance Company was going to build it with city zoning help, with city clearing out the property, selling it to Stuyvesant Town with tax benefits, all kinds of things that today would be the sign of state action. And MetLife said it's going to be all white because the president of MetLife was quoted as saying this in the 1940s. Well, colored people and white people, they don't get along, they don't live together. So based on that, they said this is going to be an all-white housing project. A case was brought. It failed in the New York Court of Appeals by a vote of 4-3, and then a certiorari petition was filed with the U.S. Supreme Court. When the petition was filed, I think when it was first filed, there were enough justices on the court who would have voted to grant certiorari and taken the case to the Supreme Court. Two of those justices suddenly died by coincidence in the summer of 1949, one of them being Justice Frank Murphy. Anybody who know who Justice Frank Murphy was? Justice Frank Murphy was, had what? Governor of Michigan. He'd been a judge on the Recorder's Court in Detroit, became governor of Michigan, basically energized the labor movement by refusing to call out the National Guard to stop the sit-down strike, became Attorney General of the United States, started the first civil rights prosecutions of Southern sheriffs who were beating and killing black people, and then went on the Supreme Court, was on the Supreme Court very briefly. He was one of the few justices who dissented in the Japanese internment cases. He said that was unconstitutional. He was often derided as a person who wasn't that bright. People said, well, Felix Frankfurter is a real genius. Well, that may be true, but Justice Murphy got the cases all right, and Justice Frankfurter got a lot of them very wrong. Anyway, Justice Murphy suddenly died in the summer of 1949. Also Justice Rutledge, another great justice from Iowa, these Midwestern justices, and they made the difference in the Supreme Court denying certiorari in 1950 on the Stuyvesant Town case. And if they had been there, things might have turned out very differently. So is that the story you were looking for?
Yeah.
And basically what we're arguing is affirmative action. We're there for whites all along,
Yeah,
state
that's right.
action.
That's right. Well, we're going to have to wrap it up pretty quick. What you would have heard about, the segregation cases, and then we're going to talk a great deal about Brown, and then Brown 2 in 1955, and some of the later desegregation cases in the 1970s, which pretty much neutered it, especially in the busing case in Detroit, Purpose and Effect, and John Roberts and the Voting Rights Act of 1965, affirmative action. I wanted to end, though, talking about Professor Burton, if you would, talking about this incredible brief that you have submitted to the Supreme Court and its effect so far for the arguments that are going to take place day after tomorrow.
Well, we can see, but I think it might be more interesting to go back to the Voting Rights Act. I mean, unless you really want me to, people are welcome to look at the brief, and
Okay, let's go back
it's
to
all
that
sort
then.
of laid out there. My reason to do this, and I was conflicted, but I am so tired of justices writing this fake history, that particularly originalists, at least, I don't think it'll affect how the court's going to, at least deal with it and squirm with original intent and what they intended as historians. Only historians signed this brief. all teaching and teaching this period and researching it and saying, here it is if you really are original intent. Because Armand had written an article years ago about, and I can never remember the title, but basically justice shouldn't.
The title of the article was, "Why do we let judges say anything about history when we know they'll get it all wrong?"
But it goes to your idea of evidence of that has to matter. And so you can't cherry pick the Constitution, I think.
Well, you can if you have life tenure.
Well, maybe.
And if you indulge in what's called law office history, right? What's law office history? Law office history is you have a client who says, I need this result. You go, you say, well, I'm a lawyer. I'll go cherry pick the pieces of history that I like, and I'll write something I call history, which is just a total fraud.
And that's not what historians do.
Okay.
But at any rate,
But that's why they're not on the Supreme Court.
But I think people might, this is something
Yeah,
I think
this
it's
was, I
very
thought,
important that we show this book. And so I'd like to, if that's okay with you,
Yeah, that's
Tim, I
fine.
really will as you want to.
Yeah.
But
So in the book, the most interesting story I found in your book, among many, was Chief Justice Roberts, acting like, in a way, kind of like a chess player, one step at a time, 3 moves ahead. And when they struck down the section,
Section 4,
Section 4 of the
which is
Voting Rights
formula.
Act. Yeah, the preclearance.
Yeah,
The
right.
preclearance.
Same.
The way he did the opinion is he cites Northwest Austin, citing misquoting South Carolina versus Katzenbach, and
It
comes
says
up,
just the opposite.
Yeah, we just
He
said just the
ellipsed
opposite.
words
Leaves out 22 crucial words.
and creates out of whole cloth the idea of state sovereignty.
Yeah,
It's not, it says the opposite. Now, whether he did it or a clerk and he missed it, but it's created what has become a very dangerous thing for democracy, I think, to get away with that and not be caught. It just,
But I think what we've tried to show is that the sad part is that is more the rule than the exception. And that's the real tragedy.
and of course, I like my quote that Armand took out. He and my wife took out all the good things. I should show you the real book of what they took out. But history doesn't repeat, but there are echoes, and the idea things are not as they were. And in fact, it's argued in 2 recent court cases that Bronovich, that Alito was right. Things are not like 1980. They are worse. We skipped. It's not like 1980. Everybody agreed in 1982. Everybody has a right to vote. Let's dilute their vote. Let's make it have less meaning, but we're not going to stop them from voting. They've gone back to 1898 in Williams versus Mississippi and say, let's stop people from voting because they're going to vote differently than my political party. And often they're wrong. They wouldn't, I think, if they would appeal to the issues as opposed to just assuming that black people or Hispanics or others are going to vote a certain way. But it's a tragedy to see democracy going back to this Jim Crow period. And I was going to say, if you got to that question, that's when Reconstruction ends in the Civil War, is 1896, 1898. Until then, and what was the federal election bill, people always had hope for the next election, And that's, thank goodness, the courts came in and did the right thing. And now the courts are undoing the right, if you believe in democracy. Now, if you believe in authoritarianism, like it seems a lot of voters do, then I can understand why you don't want democracy to work and people to vote. But if you believe in the Declaration of Independence and the Constitution, you want everyone to vote. And I'll quickly say, I'll never forget when I was in a Texas case redistricting, and a judge who I'd been told by the Justice Department, he hates expert witnesses. He just had one in tears. Don't let it get to you. He took a liking to me, invited me to come to his ranch and bring my 5 children and wife and ride horse. And he turned to me. I never heard a judge ever say that he was of a political party. He said, you know, Professor Burton, I'm a Republican, but how can we have democracy? This was about 1990, maybe. If young people don't vote, what can we do to get people to vote? The next time I was testifying was the voter ID law, and it gave me the perfect time because I said on cross, I said, well, you know, I'm really sort of surprised that Texas is doing this. The last time I was here, you know, it was very different. And so the Cross, the Attorney General, took the bait, and he said, well, what was that? And I said, well, the last time I had a judge ask me, how are we going to have democracy survive if people don't vote? Now I'm here in Texas when you're trying to stop people to vote. What's happened in between? And then I was able to explain it. Yeah.
Mm-hmm. Well, we're going to have to stop it there. Thank you so much.
I'm going to give you all an assignment.
Okay.
You're interested enough to come here today. What you might want to do, any one of you, go in the book, pick one case, any case, where we have criticized what the court did, and go read the case yourself and see if you think we got it right or maybe we've been unfair to that court. Just read one case. And I think that would be, I would feel well paid if you read one case.
And all of these cases and more are on the website that is listed in the book. And I can never remember, but we can look it up. Sure. I will say, you know, this is self-promotion, but P.T. Barnum once said, without promotion, something terrible happens, nothing. So I did bring 3 books. If anybody wants books, I'd love not to carry them back in the suitcase.
Okay, thank you.
Thank you, Tim.
Thank you all for coming. Thank you, Tim.
And I wish you could have heard the rest of the questions. Tim had some great ones. Should have warned you we'd talk too much.
Okay.